Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, I got a little feedback off of that last one, the last time, and I got to honestly tell you, there were people that, and I suspect they were all millennials that, sent me some scathing emails, but I had fun laughing at them, those poor individuals that think that we owe them something. We don't owe you anything, but I appreciate the emails. That tells me you're out there listening, and our ratings went up because all the millennials started firing around, I guess. And so you set my ratings up. So I appreciate that. Keep talking about me and calling me the things that you were calling me, okay? Old fuddy-duddy and the rest of it. That's okay. I have no problem with that. Enjoy, as they say, all right? I thank you for sending my ratings up. Hey, listen, we get these inquiries all the time from employers that are very upset and irate because of the fact that people bring in frivolous claims. And I know I've spoken about this in the past someplace regarding whether or not you can recoup attorney fees when these people are bringing these false claims. Listen, I live with this day in and day out, by the week, where employers are upset because these people bring these false claims, and some of these claims, I'm just telling you flat out, some of these claims are absolutely ridiculous. And you've got these plaintiff attorneys out there that are running around. Let me back up for a second. Let me be fair to the plaintiff attorneys for a second. First of all, for the employers out there, is what you have to realize is that when an employee leaves your work environment and they leave under conditions that are not so happy for that individual, they carry that emotion into a lawyer's office. And what happens when they get there? They tell a lawyer, let me tell you what happened to me. Now look, they're giving their perspective of things. Perspective is totally subjective. Totally subjective. It doesn't have to mean it's true. It's only how they are viewing the situation. They're upset, they're emotionally charged, and they walk into this office. What do you think the attorney is going to listen to? The attorney is going to listen to his client because that client walking through the door is going to paint the worst picture in the world. They're going to turn around and say, let me tell you, this place was a horrible place to work, the whole 9 yards. Does the plaintiff attorney want to believe it? Absolutely. Why? Because he's sitting there seeing dollar signs with every sentence that comes out of that client's mouth. All right? Employment law attorneys, they're out there. Plaintiff. Okay. So, what do? They're going to take the information from that person as communicated by that person. And they're going to write the employer a letter. Now, when the employer gets that letter, of course you're going to be upset. You're going to be upset because you're going to know that the things in that letter are absolute lies. We hear it all the time. They're lies, they're lies, they're lies. Well, first of all, the person calling me is normally the owner of the company because he or she is going to be the one that's on the hook. But who is the letter talking about? The letter isn't normally talking about them. It's talking about a manager. And of course, what has the manager told the owner? Didn't happen, didn't happen, didn't happen. So first of all, let's just get that perspective understood. Because, I want to make sure that we're dealing with this, on a fair level as well. Okay. Now I'll get back to the other piece I was saying. Yeah, I think plaintiff attorneys out there don't really care about the truth. They'll tell you the truth is somewhere in the middle, and they're going to figure that some part of this must be right, has to be right. All right, because this person would not be fabricating. And there's some out there, in my opinion, that don't really care about the truth. And I tell employers all the time, it's not about the truth. It's only about what you can prove. And that's why I say this issue about documentation. I know some of you saying, oh, God, don't get them started on documentation. That's true. But I'm telling you flat out, you got to document this stuff. Now, the issue as to whether or not you can recoup attorney fees. If you're trying to recoup attorney fees, in my opinion, in a wrongful termination situation, that's going to be totally subjective. I'm not so sure that you're going to be able to get that. Why? Because the way that they look at those things is the perception of the individual. the perception of the individual, did they view it that way? And if they viewed it that way, it's going to be tough to get in front of a jury, as an example, in my opinion, all right, to be able to get in there and say, you know what, here's the facts, here's what it was, but the other person's going to be able to say whatever that they had on their mind. And employers out there, remember something. Who do you think is in a jury box? It's not managers. Managers don't have time. They're too busy working. Employees, they love being in the jury box. Why? Jury duty to them is like vacation. They're away from work. They get to sit down and listen to this stuff. Some of them is juicy. If they get on a criminal law case, it's juicy. So why don't they want to be there? So employers, you don't want to be in that situation. So when you start talking about recouping attorney fees, I just want you to understand that in order for you to recoup that you want to recoup attorney fees, you got to go through the entire process and then win the case and then be able to prove that the person brought a frivolous claim against you. All right. Now, I know I've seen some obscure cases once in a while with unique circumstances, and some of those things are out there, but that's not generally speaking. But to be able to prove that you won the case, rather, once you win it, you got to now prove that the claim was frivolous. So what are you going to do? Go back to court to prove that the claim was frivolous? Because if you won it the first time and didn't get your attorney fees back, and you spent a couple $100,000, so now you're going to spend another couple $100,000 to prove the claim is frivolous. Now the one taking your money is not going to mind representing you in court. Okay, remember that. Why? Because they're looking at it like they're getting money too. So you got to leave the emotion out of this stuff. Attorney fees, yeah, you can try and get them back. Now look, California a few years back came out and said, okay, or there was a case that said prevailing employer and wage cases can only recover attorney fees if the claim was in bad faith. Now, California, to this extent, to recover these attorney fees, they recognized that there was an issue here. Now, Labor Code Section 218.5 on its face provides that the prevailing party in any action brought for the non-payment of wages shall be awarded its reasonable attorney fees and court costs. So, thus, Labor Code Section 218.5, fee shifting provision on its face applies equally to a prevailing employee and the employer. Because before it said that the employee can get theirs if they have to go to an attorney, they can get their attorney fees. Okay, well that makes sense because they had to go and get an attorney, so that's fine. But it really says and the employer as well can do it. So some defense attorney, on behalf of the employer, argued this case because here's what it says. And, the claim was frivolous and wage and hour because that's the only place you're going to find this is in the Labor Code, California Labor Code. They said, yeah, you can get it because, it's frivolous. Now, there was a case out there where the trial court awarded attorney fees to an employer who prevailed in a wage case, alleging, among other things, that the meal and rest break violations. Now, the California Court of Appeals at that time thereafter affirmed the employer's fee award. However, the California Supreme Court ultimately reversed this outcome and it held that Labor Code Section 218.5 does not apply to meal and rest break claims, reasoning that these claims are not claims alleging non-payment of wages. The court's ruling left open the possibility that a prevailing employer could recover attorney fees and certain other types of wage-related actions. Now, what happened as a result of that? The California legislature, seeing what was coming, introduced a bill called SB 462, so check it out, to amend Labor Code Section 218.5 to provide that a prevailing employer may only recover attorney fees if a trial court finds that the employee brought the action in bad faith. The legislature then turned around and passed that bill, and then of course, Jerry Brown signed it into law, the governor of California. Now, with this amendment, it will be even more difficult and rare for an employer to recover attorney fees and wage and hour actions in California. So, who wrote this? Oh, Peter. Okay, Peter. So, in reference to this, as an example, there it is. They're going to make it hard for you to do that. And I'm going to tell you what the thought processes are. The thought processes are by the California legislators and some of these other states, in order to be fair, if you have these laws in place that if the person loses, that they're going to have to pay the attorney fees, yeah, it's going to cut down possibly on some of these frivolous claims. But it's also their logic from the legislator that it'll be a deterrent from people who want to file a legitimate claim, because they're afraid that if they don't, if they don't win, okay, that they're going to have to pay the fees for the employer. So that's a deterrent. So I'm kind of a little on a bubble about that one, because I don't think that that's an unreasonable thought. And there are some employers out there not doing it the right way, in all fairness. All right. So it's what we try to get people to do is do the right thing. Pay people what they're supposed to be paid, and they won't haul you into the labor board. And don't forget, in California, effective January 1st of this year, 2016, January 1st, that you can now be held personally liable in California for certain wage and hour violations. There's no more corporate protection. So if I know, if you know like I know, you better start doing what you're supposed to do. And if you're not sure, you need to check with somebody that's got the background to be able to assist you and advise you in this area. All right, with that last comment, it's time to close out this segment. And let me remind you that you can hear us on Facebook at Listen Up, and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday by calling 855-4J-POTS or 855-457-6887. Or you can email us at jameswilliampottsllc.com. All right, I'm Jim Potts. I will continue to fight the fight. Thank you for listening, and I will catch you next time.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.